Hey there, and welcome to the deep dive. We're jumping into some important material today, looking to pull out the essential insights and help you get up to speed fast.
That's right. We'll be your guides, navigating through the details to pinpoint exactly what you need to know.
Now, this particular deep dive focuses on some fascinating material made available by the University of London for educational purposes.
Uh-huh. And we should also mention this is brought to you by Sinorbit Academy, Sri Lanka.
Absolutely. So, our mission today, we're going to unpack the core knowledge from this document, all about how companies get formed, what promoters are, and this really interesting area of pre-incorporation contracts.
We'll definitely highlight the key concepts, the really important cases you need to remember, and the facts you should be focusing on, especially if you got an exam coming up.
Yeah, I'm actually looking forward to this one. It gets into the nitty-gritty of starting a business, setting up the company itself, and some of the legal issues that can pop up even before it officially exists. Seems very practical.
It really is. We'll look at what the law actually says, try to understand the why behind some of these rules, and crucially, frame it all in a way that helps you tackle this material effectively for your studies. So let's dive right in with the first bit, forming a company.
Okay, so how do you actually create a registered company in the UK? The source material mentions the Companies Act 2006, and it sounds like they've made the process pretty simple.
That's definitely the main takeaway. The process is intentionally straightforward. Basically, it boils down to submitting some fairly minimal paperwork to Companies House.
Right, things like who the directors and shareholders are, the shares, the name, the constitution.
Exactly, the essential details.
And the speed and cost seem, well, quite remarkable. Postal is £40, maybe 10 days. But online.
Online is the real game changer. Just £12, and usually done within 24 hours.
£12 in 24 hours. That's fast.
It is. And that speed and low cost, that's a conscious policy choice in the UK. The idea is to make company formation easy, speedy, to encourage enterprise, reduce those barriers to entry.
Makes perfect sense economically. Get businesses going, but the source does flag the potential downside. If it's easy for legitimate businesses, it could also be exploited, right?
That's always the balance, isn't it? The material mentions newer legislation, like the Economic Crime and Corporate Transparency Act 2023, which brought in things like identity checks for people registering companies, trying to tackle that risk.
Ah, so steps to mitigate it.
Yes, but the overall message is that the fundamental system remains simple and quick. Easy and speedy is still the general principle.
Okay, simple and speedy. Got it. What about this constitution, sometimes called the Articles of Association? What's its role?
The Constitution is, the company's internal rule book,
Yeah.
how meetings run, shareholder rights, that sort of thing. And again, to make life easier, the law provides model constitutions.
Oh, like templates, default rules.
Precisely. So unless you go to the trouble of creating and submitting your own custom one, the company automatically adopts the relevant model articles. There's one set for private companies, another for public.
Just another way to smooth the process, save time and money.
Exactly. Makes it cheaper and easier.
And then there are shelf companies for even more speed.
Right. These are companies already incorporated, sitting on a metaphorical shelf, not having traded. You can just buy one, change the name and directors, and you're good to go.
Wow, even faster than 24 hours.
Instantly, pretty much.
The source does prompt a thought, though. It suggests thinking about potential downsides or risks of using a shelf company based on, what a company actually is.
It's a good point for reflection. Why might buying an existing legal shell, even one that's never done anything, have different implications than starting completely fresh? Something for you to mull over using what you know about separate legal personality.
Okay, so formation. Generally easy, fast, inexpensive, with tools like model articles and shelf companies to help.
That's the picture.
So we know how it gets formed. But who are the people actually making it happen? This brings us to promoters, section 3.2 in the source material.
Yeah, promoters. The definition is quite simple at heart. A promoter is someone who takes the necessary steps to form a company. They're the driving force behind its creation.
The source notes the Companies Act 2006 doesn't actually define promoter, but the judges have stepped in. It mentions a classic case, Twycross v. Grant.
That's the one. Twycross v. Grant, way back in 1876-77, Chief Justice Cockburn gave that famous description. One who undertakes to form a company with reference to a given project and to set it going, and who takes the necessary steps to accomplish that purpose. Remember that case name. Twycross v. Grant.
Sounds like a deliberately wide definition.
It is, and intentionally so. The courts wanted to make sure that anyone really involved in getting the company off the ground could be caught by the legal duties that applied. The source actually draws a parallel to how director is defined broadly in Section 250 of the Companies Act 2006. Same sort of idea. Cast the net wide.
And why impose duties? What was the problem they were trying to stop historically?
The big historical concern was promoters abusing their position, specifically selling their own property to the new company they were forming, but at a massively inflated price.
Ah, okay. And funding this purchase with...
Money raised from the public,
Okay.
getting people to buy shares in this new, exciting company, and then using that money to pay themselves way over the odds for their property.
Right. Classic self-dealing. I can see why the law would want to clamp down on that.
Exactly. And so, to combat this, the courts imposed fiduciary duties on promoters, duties to act honestly in good faith for the benefit of the company being formed. The source points to Dignam and Lowry, sections 4.7 to 4.13, if you want the deep dive on those duties, but it also says detailed knowledge isn't essential for this particular material.
Okay. But then the source makes a really important point. It says the whole concept of the promoter and these specific duties are actually less significant in practice today. Why is that?
This is a key development to grasp. It's mainly because the rules around selling shares to the public, public offerings or IPOs have become much, much tighter and more comprehensive over the years.
Ah, so the specific mischief, the promoter duties aimed at that dodgy sale of overpriced assets funded by public investors, is now effectively stopped by these broader regulations governing how companies raise money from the public.
Precisely. Those rules apply regardless of whether the person involved fits the old Twycross v. Grant definition of a promoter. So while understanding the history and the definition is important context, why the law developed the practical impact of being labeled a promoter today is less, because other rules now provide that protection.
Got it. Understand the history, Twycross v. Grant.
Yeah.
Understand the definition, but recognize that the duties themselves aren't the main focus now because other laws cover that ground. Makes sense. Okay, let's shift to something the source says is of greater practical importance today. Pre-incorporation contracts.
Yes, Section 3.3. This is definitely more current in terms of risk. It's all about contracts that someone tries to make for a company before that company legally exists.
And how do you know for sure if a contract is pre-incorporation?
You check the date on the company's certificate of incorporation, that's its official birth certificate, issued by Companies House. If the contract was signed before the date on that certificate, boom, it's a pre-incorporation contract.
Right. So let's take an example. Say I'm setting up Awesome Gadgets Ltd. I find the perfect office space, I'm really keen, and I sign the lease for Awesome Gadgets Ltd. on Monday. But the company registration only gets finalized, and the certificate issued on Wednesday. That lease signed on Monday. That's pre-incorporation.
Exactly, and that raises the crucial question. Who is actually bound by that lease signed on Monday? Awesome Gadgets Ltd. Didn't exist then. So, can the landlord demand rent from the company? Or do they come after you, the person who signed?
That's the problem. What did the old law say?
The source touches on the old common law. Basically, the company couldn't be liable logical, as it didn't exist. Whether the person signing was liable wasn't always crystal clear, depended on the specifics. But honestly, the old law isn't the main focus now.
Because there's a statute.
Yes, Section 51 of the Companies Act 2006. This is absolutely critical. Section 51CA 2006. You need to know this section number.
Section 51CA 2006. Okay. What does it actually say? The source gives the wording.
It says, paraphrasing slightly, a contract which purports to be made by or on behalf of a company at a time when the company has not been formed has effect, subject to any agreement to the contrary, as one made with the person purporting to act for the company, and he is personally liable on the contract accordingly. Let's repeat that section. Section 51 Ton 1 CA 2006.
Okay, that's quite dense. Let's break it down like the source does. 3 key points.
Point 1. The company still isn't liable. Even under S.51, a contract made before formation cannot bind the company after it's formed.
Company not liable. Check. Point 2.
The person who actually signed the contract, the one purporting to act for the non-existing company, is personally liable. So in your Awesome Gadgets example, you would be personally on the hook for that lease.
Ouch. Okay, the promoter is personally liable. That's a big deal. Point 3.
This personal liability is the default rule, but it's subject to any agreement to the contrary. That means it is possible to avoid personal liability if the contract itself contains an agreement saying so.
Right, that agreement to the contrary, escape hatch. But how clear does that agreement need to be? Is it enough if the landlord just knew Awesome Gadgets wasn't formed yet?
That's where the case law comes in, and it's crucial. The key case here is Phonogram Ltd v. Lane. Remember that name? Phonogram Ltd v. Lane, 1982.
Phonogram. What does it say about agreement to the contrary?
Lord Denning in Phonogram was very clear. To escape personal liability under S.51, the contract needs to expressly state that the individual signing will not be personally bound. It requires an express agreement. Just implying it, or the other side knowing the company isn't formed, isn't enough.
So, back to my lease. Just signing for Awesome Gadgets Ltd. does not get me off the hook under S.51, according to Phonogram.
Correct. You'd need a specific clause written into the lease, something like, it is agreed that your name signs this contract solely on behalf of the proposed company, Awesome Gadgets Ltd., and shall incur no personal liability hereunder, the liability resting with the company if and when incorporated. Something that explicitly excludes your personal liability.
That's a very high bar. Express exclusion needed.
It is.
Yeah.
And the rationale, as the source points out, is about protecting the third party, the landlord in your case. They enter into a contract, they need someone to be liable. If the company doesn't exist, S.51 defaults liability onto the individual who acted, unless that individual is clearly contracted out of it.
It puts the onus firmly on the promoter to protect themselves explicitly. Seems strict.
It is strict, which is why knowing about S.51 in Phonogram is so important. Now, there's a second key case mentioned, Bramis Ltd v. Wise Finance Co. Ltd.
Bramis Ltd v. Wise Finance Co. Ltd. Okay, what did Bramis add?
Bramis looked at it from the other direction. If the person signing is personally liable under S.51, can they also enforce the contract against the third party? Say, if the landlord in your example tried to back out.
So can the promoter sue on the contract too?
Yes, and the Court of Appeal in Bramis in 2002 held that ordinarily, yes, they can. Section 51 effectively creates a contract between the individual promoter and the third party. So rights and liabilities generally go both ways.
Okay, so S.51 means the promoter is liable, Phonogram, but also means the promoter can generally sue, Bramist, unless there's that express agreement otherwise.
That's the essence of it. Now, the source does add a practical point. The actual risk of getting caught by S.51 might be lower today.
And that comes back to what we said at the start, how quick formation is now.
Exactly. Because you can form a company online in 24 hours for £12 or via shelf company instantly. There's often less need to sign contracts before the company legally exists. You can just wait that day or buy the shelf company first.
Makes sense.
Yeah.
The window for error is smaller, but...
But the danger is still there if you do sign too early and don't have that express exclusion clause. Speed helps avoid the problem, but doesn't change the law if the problem arises.
So, Section 51, Phonogram, Bramist, still absolutely vital to understand.
Without a doubt.
Right. We've covered the formation process, promoters and their history, and the crucial area of pre-incorporation contracts. Now, let's switch gears slightly and focus on how you listening should approach this for studying, especially for exams.
Yes, let's nail this down. The source itself provides great clues. First stop, the learning outcomes listed at the beginning of the chapter or section. Treat those as your study checklist.
Can you explain formation? Define promoter, explain why they had duties historically, describe the pre-incorporation contract problem, explain Section 51 CA 2006, and really key, can you assess how S.51 applies in a scenario? Can you tick all those boxes?
If you can confidently say yes to all of those, you're in good shape. Use them to test yourself. The source also points to the core text Dignam and Lowry, Chapter 4, for the more detailed reading.
And let's repeat those key cases one more time. Phonogram Ltd v. Lane.
And Bramist Ltd v. Wise Finance Co. Ltd. You need to know the names, the basic facts, and critically, what they established about Section 51, especially Phonogram on the agreement to the contrary part.
And Section 51 CA 2006 itself. Know it. Burn it into your memory.
Know its main effects. Company. Not liable. The person signing, personally liable. The escape route. And express agreement to the contrary.
To see how this gets tested, the source suggests looking at the sample examination questions. These topics, especially pre-incorporation contracts, often come up in problem questions.
Sample question 2 is a classic example. It gives you a little story. Someone signs a deal before the company is formed and asks about liability.
So how would you tackle that? First step.
First, spot the issue. Read the dates. Contract signed before the certificate of incorporation date. Okay, this is a pre-incorporation contract issue.
Step 2. State the law. What's the main rule?
Section 51 CA 2006 is the governing rule.
Step 3. Explain the rule's effect. What's the default under S.51?
The default is company isn't liable. The individual who acted is personally liable.
Step 4. Mention the exception.
Yes. Mention that liability is subject to any agreement to the contrary.
Step 5. Bring in the case law on the exception.
Crucially, bring in phonogram, explaining it requires an express agreement to exclude personal liability, not implied, express.
And finally, step 6. Apply it all to the facts in the question. Look at the wording used when the person signed, or any clauses in the contract described. Does that wording meet the high bar set by phonogram for an express exclusion? That's where the analysis happens.
Exactly. Work through those steps methodically. Practicing with those sample questions is the best way to get comfortable with applying Section 51 and phonogram.
Okay, fantastic. So wrapping up this deep dive, we've looked at the surprisingly easy UK company formation process. We've explored promoters, who they are, the historical reasons for their duties, Coy Cross v. Grant, and why those duties are less of a focus now. And we spent significant time on the very practical issue of pre-incorporation contracts.
Focusing heavily there on the absolute core. Section 51 CA 2006, remember it. Its effects. Company not bound, promoter is bound personally by default, and the key case is interpreting it. Phonogram Ltd v. Lane on needing an express agreement to escape liability, and Bramist Ltd v. Wise Finance Co. Ltd on the promoter usually being able to enforce the contract too.
Remember those key terms: promoter, pre-incorporation contract, Section 51, phonogram, Bramist, and definitely use the reflect and review section in the source material. It's designed as a self-check tool.
It really helps consolidate your understanding.
And maybe a final thought for you to ponder, linking back to that easy formation. Now that setting up a company can literally be done in hours online, does Section 51 still strike the right balance? Is it still essential to protect third parties dealing with fledgling businesses? Or could it sometimes be a bit of a trap for enthusiastic entrepreneurs who just don't realize the strictness of signing something a day too early without that magic no personal liability clause?
It's an interesting policy question to reflect on, how the law adapts or doesn't adapt to changing practicalities.
We really hope this deep dive has clarified these areas for you and given you a solid framework for your studies.
You should now have a much better handle on the key concepts and how to apply them. You can definitely nail this section.
So nothing left but to say good luck for all of you for the exam, and thank you for joining us for this deep dive.
Yeah, hope it was useful. Until next time.